This is breaking news from the Las Vegas Review-Journal, sponsored by Michael Gaughan's South Point Hotel, Casino, and Spa.
Yes, okay. As plaintiffs, I need to know who the parties are. So who are the parties, and let's make that the caption. And I'd sure like to know what standing Mr. Cook and Mr. Trask has. You know, obviously we don't have a complaint. I've allowed this action to proceed basically under Rule 81 of the Nevada Rules of Civil Procedure. So it's a moving target, and so we need to know who the parties are.
Your Honor, I appreciate you raising the issue because it got confusing on our end too, because the clerk's office changed it from something that we have. So I agree, it makes sense to nail this down now. If it's okay, I will read into the record the plaintiffs. The Las Vegas Review-Journal, Inc., which is the company that owns the newspaper. The publisher and editor, which is Keith Moyer.
Now, why do these people have standing? Isn't it just the paper? I mean, we are here. Now, understand, my role here is very limited, and it is dealing with the seizure of Mr. Gehrman's devices, his electronic devices, which have thankfully been enumerated within the preliminary injunction order. So what standing do these individuals have in that? I can see the RJ that if there's information in there, Mr. Gehrman was an employee or independent contractor, he's a reporter, they may have standing to challenge the information that may be on these devices. But what does Mr. Moyer, Mr. Cook, and Ms. Trask, what is their standing in that? They're employees as well.
They are all employees, Your Honor, and all of them have standing, both the company and the individuals. The Nevada Shield statute is written in terms of speaking about individuals, and in fact, in many proceedings, these are usually subpoena proceedings, not search warrant seizures.
Right.
And it's often an individual reporter who is subpoenaed to come testify or give documents about confidential sources or unpublished information. And so in those proceedings, typically it is the reporter and the company they work for asserting the privilege. And so that's why we have everybody here, and particularly because Metro and the other parties are claiming that the newspaper itself does not have standing. So we, in order to make the record clear, look, yes, it does have standing, A, and B, so do all these individuals. We added them into our motion via the amendment of motion.
Okay, well, I'm not saying that Mr. Cook or Mr. Moyer have standing to assert the privilege of Mr. Gehrman. These are his confidential sources that we're talking about that may be in his phone. By the way, we don't necessarily know what's on these phones. The phones and these devices, they're storage devices. We don't know what's in that, and I see it akin to a closet. We don't know what's in the closet because we haven't opened up that door.
Your Honor, my response to that is there are facts that support the notion that it is highly likely that information belonging to the Review-Journal is on the devices. And Mr. Gehrman was an investigative reporter among other investigative reporters, and he worked co-equally with those other reporters. And then he also worked up a chain with editors all the way going up to the publisher. And in the Diaz case, which is a Nevada Supreme Court case, one of the more recent ones on the Shield law, the publisher was one of the parties asserting the privilege. And the court ruled in favor of the publisher and the newspaper. So we have added in the other parties because they work with Mr. Gehrman. They worked with him to produce the ultimate work product. So they have equal rights and interests in the material that remains on the devices.
Okay, well, I'm still not seeing it, but I understand the paper is a party. Okay, so the caption's not going to have Mr. Moyer, Mr. Cook, Ms. Trask, or any employee, because I'm seeing that these are Mr. Gehrman's devices, and whatever is on it is his information and his sources and so forth. So we'll put RJ, and you've got the state of Nevada as a defendant. You've got Mr. Tellis as a defendant, and then Metro as a defendant, right?
Your Honor, may I add one thing?
Sure.
Thank you, Your Honor. The material that Mr. German has gathered, he gathered in the course of his responsibilities as a reporter. He shares that information with his editors and his publisher. Now that he is gone, the material is still theirs for their use in performing their function as a news media. It does belong to them, that's our position, because he didn't have it in any other context than as an employee, independent contractor, had certain arrangements with the paper. So in order for those folks to protect their interests now in what was always theirs, because Mr. German always shared his material with his editors and his co-reporters, and now they need to have that information in the closet to continue to develop stories. Otherwise, the murder would mean that's the end of the work of the Review Journal. So I would ask you to reconsider including the people who believe the importance of retrieving that material at some juncture so that they can perform their media responsibilities.
Okay, we're going to leave it as the RJ versus all these other defendants. Do you have any problem with that?
No, I don't have, there's so many procedural irregularities that it's hard to keep track of them. They unilaterally changed this caption without asking for permission. There's big problems on that side of the caption, as the court has appropriately pointed out. But there's problems on the other side of the caption. Because the court mentioned Mr. Tellis and the state of Nevada. That's not how they've named the defendants. Metro is a political subdivision, and I understand that, we have the capacity to be sued. But the public defender's office and the district attorney's office, my understanding, they can speak for themselves, but my understanding is that those are not entities that have the capacity to be sued.
I agree.
So we're playing fast and loose with a lot of different things. They're here in good faith because they're trying to get this worked out. They're making these appearances, on behalf of their clients, whoever they are. But I completely agree with the court. There's a lot of issues with the caption.
Okay.
For starters.
Okay, the caption's going to be Las Vegas Review Journal Inc. versus the state of Nevada, Mr. Tellis, and Las Vegas Metropolitan Police Department, because they're the holder of the devices, okay?
Okay.
And also, they're the ones that are apparently seeking, they're still the investigative body.
I think that's much more appropriate.
Okay.
Just for the record then, Your Honor, they are acting as agents of the district attorney in the prosecution of this case. And when you understand the argument being made on the other side as to why they need it, it's because the DA is saying that it has some obligation to Mr. Tellis. So not to include them as parties, since they're basically causing the dilemma. Metro has the property, but the purpose of the property, the purpose of the prosecution is because the DA wants to get it and then figure out if there is even something on there that would go to Mr. Tellis. So we would ask you to include them, Your Honor, because the Metro is merely like an agent at this point in time. I think that it's very important to have all the potential parties that might have access to this material enjoined as a party.
Well, the way I'm looking at it, you guys have created a mess, and we're trying to clean it up, all right? I'm not going to, because the DA's office, they represent the state of Nevada, and I'm not going to change it or make it any more complicated than it needs to be, okay?
Thank you, Your Honor.
All right, the first order of business is that we've got a motion that I'm going to entertain in terms of the request to participate as an amicus curiae. Again, I think we're making this way more complicated than what it needs to be. If the reporters want to, as a group, want to be proceeding in amicus curiae, I see that as at the appellate level, not here. Okay? Most certainly, the other reporters, groups, they can help the RJ, they can align with the RJ and so forth, but I just don't think that that's appropriate at this point, so I'm going to deny that motion.
And just for the record, Honor, and I appreciate what you said, the press often does weigh in, even at the trial level, because of the gravity of the issues, but I hear your good one.
Okay, let's get back to the preliminary injunction. Obviously, I was hoping that the parties would come together to see if we could come up to a resolution that everybody may not be that happy with, but also not too upset by. And apparently that did not happen.
Well, here we are.
Okay, let's turn off any cell phones. Okay?
I think probably where we should really begin is the fact that the court entered the preliminary injunction yesterday, and as I indicated last week, we were intending to appeal from that, and we have.
Oh.
So it was just happening that's why I was late. But there has been a notice of appeal that's been filed. I think really before we proceed any further, my position would be to divest the court of any further jurisdiction. And it's a little bit more complicated than a final judgment in a regular case.
Well, did you file an appeal or did you file for a writ?
An appeal. Because
that's not a final appealable order.
right, but NRP 3A, it lists a preliminary injunction as an interlocutory order that can be appealed from. Yeah. So it definitely can be appealed from. The question becomes, I did a little research on this last night. The issue becomes, generally speaking, when a notice of appeal is filed, it divests the court of any further jurisdiction other than a wrap up. If it was a jury trial, you'd be able to hear motions for attorney's fees or whatnot, or I guess a motion to amend the final judgment. But this is a little bit different because it's a preliminary injunction. So the question becomes, what is left of the case that isn't a part of the court's preliminary injunction? Because anything that's within the confines of the preliminary injunction or related to the preliminary injunction or the issues within the preliminary injunction are now at the Supreme Court.
Okay.
So my position is that there is nothing left. This whole case is about stopping the parties on this side of the courtroom from conducting a search for all the reasons that the RJ has stated, and those are the same issues that are going to be now have to be heard by the Supreme Court. I think that's probably the best place anyway. Like we talked about last week, one way or the other, someone has to, find their way to the Supreme Court. So if this is the vehicle that they've chosen, they chose to get a preliminary injunction, it's directly 100% appealable, and that's what's happened.
Okay. I assume this is a surprise to the RJ.
Your Honor, nothing's in this case is a surprise anymore. I'm not sure that they're accurate about the jurisdictional issue. This happened this morning, haven't had time to look at it. I don't know that the entry of an appeal, the filing of a notice of appeal on an injunction that is a preliminary and only partial piece of a case where we seek a lot of relief, right? We sought an injunction leading to an entry of a protocol, leading to figuring out if there's a dispute over anything, leading to, if there is, an adjudication of the rights at the end of the day. So it seems to me that this is just the first piece in that puzzle. And the more important issue for us, Your Honor, is that, as you noted, everybody was unhappy with the preliminary injunction. And we did, I think you saw, we did provide our draft. We tried to get a meeting twice, never had a meeting on that. So,
That's false.
Well, I'll listen to you.
I know.
Go ahead.
What?
Well, don't worry about it.
okay.
Okay, so
Well,
it's
if I
not-
know the
it's
false,
not false.
if I know the falseness is coming, I need to say specifically that I have two emails, one from Thursday night and one from, I think, Monday night, requesting a meeting to talk about both orders, the preliminary injunction, our proposed preliminary injunction order and their provisions thereto, and our proposed protocol order, which hasn't, we filed that in this court this morning, Your Honor. I'm not sure you've seen that yet,
I
but,
have not.
okay. Let's just put a pin in that for a second. So, this is just the preliminary part of this proceeding. We actually also filed this morning an ex parte emergency motion for TRO on the two things that were stricken from the preliminary injunction order. Because, and I appreciate judges want the parties to try to come to an agreement, and oftentimes they can. This is just one of those special cases where kind of meeting in the middle doesn't work. It literally doesn't work. The minute that our privilege is breached, it's breached. And the other two elements would breach the privilege forever. So we couldn't agree to leave those out. And I don't know if Your Honor wants to entertain that, and we're happy to entertain that because it's important to know that the car, Mr. Bierman's car, was in his garage. One of our reporters saw it. They saw what appeared to be fingerprint dust all over it. And we have learned that it's the kind of car that probably has all the same stuff living in its electronics that are on Mr. Bierman's cell phone, which is one of the 6 C's devices. So,
To me, that's a different issue. I mean, it's not the scope of the preliminary injunction, and you're raising something new. This is certainly new for me. But I'm concerned with respect to the other devices that are listed. It seems to me that I don't have jurisdiction if the notice of appeal, by the way, was filed at 9:29 this morning. So I don't think I've got jurisdiction on that. If you're looking to protect other things, I think that you're going to have to file something else.
we did.
Or if they believe that Your Honor should have entered their version of a preliminary injunction, then they can cross appeal.
And we are planning to cross appeal.
So yeah, I see that there was an opposition filed at 9:34 this morning.
And right around the same time, Your Honor, is the ex parte emergency motion for TRO on items, we have 1, 2, and 3. You've entered 1. Number 2 is cars.
Well, the car's in the garage, or is it at Metro?
I don't know where the cars are. They haven't told us whether they have possession of the cars. I think they have access to the cars based on
Okay,
the evidence that we've
you've used
before.
plural now. Is there more than one car?
We, in an abundance of caution, wanted the order to cover any cars that Metro believes he may have driven. Because sometimes, you drive your wife's car to work, or you drive, someone else's car.
Okay, well, I understand now. I don't know anything about Mr. Bierman's personal life, but I understand he wasn't married.
No, I was using an
Okay,
hypothetical.
well, and I have a problem with just doing a blanket cars.
It's not cars. It's cars that A, Metro believes he may have driven, and B, that a reasonable person would have reason to believe might contain news gathering material. So if it was like a Pinto from 20 years ago, we're not worried about it.
Well, I was going to say,
It's a Honda Civic that's from 2021, which has very advanced Bluetooth technology in it.
I was going to say my husband owns a 1972 Datsun 240Z. There's no need
Right.
to see, to worry about that.
Well, and because I want to be clear, our proposed order covers what if there are papers in the car that a reasonable person would think are his news gathering materials. It would cover that too. But the main thing that came to us was the car itself, because it's very analogous to the devices. And then item 3, Your Honor, is, again, I know you're trying to be specific, but it is specific in the sense that it is material that that Metro comes into possession of, that a reasonable person would believe might contain our news gathering material on it. So it is restricted. It's not just anything they get into possession of.
Okay, well, to me, that's going to be an issue for a different day because it was just filed at 9:34. The state, Mr. Tellis, Metro have not even had an opportunity to review it any more than I have, and I think they've got a right to be able to go through it. The main concern that I had, to be honest with you, is to get a preliminary injunction on board that was very specific. You itemized what you were concerned about, and I wanted to get rid of that TRO because I was concerned about it limiting Metro and the state and Mr. Tellis's ability to undergo an investigation when we were talking about, let's see, precluding them from inspecting, searching any device seized.
Right.
You know, I was really concerned about
That
that.
was not language that we proposed, Your Honor. It was slightly tweaked by the judge who entered the order, but.
No, it wasn't. It was.
It was?
It was
Okay.
not.
I may be misspeaking. As I sit here now, I look at it and I didn't think it was the same, but it may well be the same.
I was going to say, I see Ballard Spar all over it in terms of, and the only thing that was stricken was the term proposed in the,
Okay, fair
The
enough,
title.
Your Honor. Fair
And it
enough.
was ex parte, so I don't know.
But Your Honor, one thing that's getting lost in this discussion is about the preliminary injunction. This is not a case where we know what they have. It's a homicide investigation, and for very good and important reasons, they can't tell us everything that they have, right? And we're not asking them to. So we're trying to craft a specific order that fully protects our rights, because it's got to cover all the news gathering privileged material. Otherwise, everything we're talking here is out the window. We've lost. So that's why it has these three categories cabined to what a reasonable person in their shoes as investigators at Metro, knowing that he was a journalist, might reasonably believe would contain news gathering material. We cabined, in other words, we cabined it as much as humanly possible in a case like this where we can't possibly know what they have. Does that make sense?
I understand.
Okay.
I understand too, but it couldn't be any more vague. And it's a never-ending expansion of what they might someday think might contain news gathering materials. I mean, let's go back. They didn't even know that we had these 6 devices. We told them that we had these 6 devices because we were trying to operate in good faith. The only reason they know about this is because we told them. So, and they made it really clear too. They've given us all these, in particular this federal statute that they say they can sue us under for civil damages if we violate these reporter privileges. So I think what protects them is our knowledge that if we make a misstep and go insert something that has news gathering materials on it, then we're exposed to that liability. So otherwise, this is vague and ambiguous and never ending. Tomorrow it could be some other device or materials or vehicle or who knows what that they'll say has news gathering material on it. So, I mean, I object to the expansion of the preliminary injunction.
Well, I'm going to just tell you right now, just sitting here without researching the issue, I don't think I've got jurisdiction anymore. I think it's going, there is no complaint, by the way, filed. The only issue that is before me is the preliminary injunction issue. I had issued a preliminary injunction. I was hoping to meet with you today to see what we could do to adhere to the interests of the RJ and reporters and so forth, the press, versus the investigation that needs to be done by the state, by Mr. Tallis, in order to get the ball rolling. Unfortunately, what I'm concerned about, Mr. Christian, is with this preliminary injunction, which means that Metro cannot open up any of these devices. They can store these storage devices, and that's all they can do, which is going to hinder, I think, the investigation and possibly extend the trial out in the criminal case. That's a concern I have to.
Well, my colleagues could speak to that better, but I mean, it already has. So, again, that's why, let's see what the Supreme Court says. Maybe it can be expedited. Ultimately, whatever, if you had decided that we were totally right and we could start searching right now, they would be running off the Supreme Court, and we'd be operating at our own risk if we went and started opening the devices and searching them. So, I mean, we understand that. The appeal doesn't mean that the preliminary injunction goes away. It's still in place. I mean, until the Supreme Court hears this, we're enjoined. We understand that.
Your Honor, just for the record, the council just talked about how they want to expedite this. The court should be clear. I specifically contacted him to have a meeting at the request of the court to see if we could work something out. I was told he wasn't working Friday, and I said, well, how about Monday? We offered to do a conference call. We got no response to that. So I don't want the court to think that we didn't try to sit with them. That's number one. And number two, it's a little strange that we got told about the jurisdiction question after you had the discussion about who the party should be. If there wasn't jurisdiction when we started, and they remained silent while you narrowed this, I'm a little uncomfortable with that, Your Honor. Why didn't they tell us and you at the beginning, Your Honor, it's nice to be here this morning, but you don't have jurisdiction? We had a whole dialogue about who the parties are. So I really leave it to you, Your Honor. If you don't have jurisdiction, then I don't know how the parties got narrowed.
Okay, well, I didn't have jurisdiction as of 9:29 this morning, so I don't, frankly, whether we had that discussion before or after, but.
Your Honor.
I only bring it up, Your Honor, because I, to be quite honest, was surprised that I was told that we didn't try to talk to them. And I don't understand that. And so that led me to be concerned about the fact that it's a little fast and loose to talk about jurisdiction after we actually have not contentious, but a dispute about who the parties are. And I want that in the record. Thank you.
Okay.
Your Honor, you started a discussion. I mean, if you want to go back and leave all of the other parties in, that's fine, because it's even more obvious. It'll be even more obvious to the Supreme Court if there was something wrong going on.
Well,
That's fine with me.
there are no parties because the initial filing is in Ray State versus Telus.
Right.
And then I started getting these filings,
Yeah.
which was, it was a moving target on who the parties were. We do not have a complaint.
Right.
And to me, the sole issue here is dealing with the seizure of these storage devices as to what it might contain. And then it gets down to what I was hoping to resolve is getting into who is going to look at the devices. Frankly, I was going to ask the state to identify what they believe is on these phones. In essence, tell me what you want out of these phones, and then have a third party or somebody look at the thing. But we're not there anymore.
Right.
Okay?
Your Honor, I think I am obliged to actually tell you this. There's a case of Manley versus Manley, 122 Nevada 849. It says appeals from interlocutory orders do not divest the district court of jurisdiction over the case. Order resolve matters that do not affect the appeal's merits.
Exactly.
So-
That's what I just said.
Okay.
If the court is divested of jurisdiction of anything that is within the confines of the preliminary injunction, any issues that the court resolved in the preliminary injunction are now in the Supreme Court. So that's exactly what I said. What's left? What is the court going to decide that's remaining in the case? If the court's decided that they're entitled to enjoin and will prevent the search because they claim they have an interest in it, and that's the issue that's going to be on the appeal. Is that really accurate or not? We say it's not, and we're entitled to appeal from that. If we want to brief it further, I'm fine with that. But
Well, I don't need you guys to brief any further. I'll look at the Manley case though, but at this point, out of an abundance of caution, I'm not going to proceed any further.
Okay, Your Honor, may I state just two things for the record then? If the part of the preliminary injunction is deciding whether there is substantial likelihood of success on the merits. So all of the briefing on the merits, I think is part, has to be acknowledged to be part of the appeal.
of course,
Okay,
the record on appeal.
I'm sorry, Your Honor? Yeah, one at a time. My court reporter is really good at what she does. She's been with me almost 16 years, but she's never mastered the art of taking down two people at the same time.
I think the rest of the rules of appellate procedure will apply, as far as I know. We'll have to do a record on appeal, and it will include everything. Plus, we have a duty to confer with them when it comes to the record on appeal, so of course.
So I want to be super clear. We filed two things this morning. One is a sort of a reply in support of the motion for return, and opposition to counter motion to dismiss. We think that is part of this record. And then the second thing we filed is the ex parte motion for TRO on items 2 and 3, the cars and future stuff. We think that is part of the record on appeal.
I mean, I'm happy to look at that, Your Honor.
And-
They always, I doubt we'll have a disagreement, because even if we did, they do their own record on appeal.
Okay.
And I misspoke, Your Honor, I'm sorry, may I just
That's
say
an
this?
appendix.
On the TRO motion, that's actually pending before you. And to your point of everyone should get a right to respond, we would orally ask that that be heard on an order shortening time.
There is no pending motion. The last thing that was filed was the opposition plaintiff's further support of motion for return of seized property according to special master, and in opposition, that's the last filing. In fact, let me get the whole thing out. Plaintiffs in further support of motion for return of seized property and appointment of special master to conduct reporter's privilege review, and in opposition to counter motion to dismiss. That's the last thing that was filed.
So we're checking, Your Honor, because we did get a notification from the court that it was filed. Now, we may be in a different department, so let's clear that. It was filed before their notice of appeal at 9/28. Does it say it's going to a different department?
Let me ask you this, was it, did you submit it to the District Court 22 inbox?
Yeah, in this case, no. It's called, let me see what it's called. And then that's the notice of appeal, I'm sorry.
Okay,
A lot of things were filed this morning, Your Honor, sorry, just trying to.
I get it.
You need some glasses.
Okay, there's nothing in my.
Here it is. Second ex parte application by plaintiffs for an emergency temporary restraining order and request for preliminary injunction hearing on order shortening time. It was filed at 9:27 a.m. in this case number. So I don't know, maybe there's a delay from when the court received it and when you see it? I am not sure.
Okay, there was one filed before the notice of appeal. It is second ex parte application by plaintiffs for an emergency temporary restraining order request for preliminary injunction hearing on order shortening time.
That's the one, Your Honor. And
Okay.
that's the one that addresses items 2 and 3.
Okay, well,
Which is on appeal. The
okay,
fact that you
No,
declined to have
only
that.
one. I'm sorry.
okay, one at a time, guys, please.
I'm sorry, but they wanted Your Honor to sign off on items 2 and 3, and Your Honor declined. So the obvious remedy for that is to cross appeal.
I have a tendency to agree with you. So, all right, I think we're done, guys. We've got,
Thank you,
I
Judge.
divested the jurisdiction.
So, Your Honor, just to be clear, is it your, are you not hearing our motion? Because I thought it was your view that items 2 and 3 were new, they were different. And so if that's the case, we are requesting that relief on an order shortening time.
Well, number one, I'm not going to hear it today, because number one, I haven't read it, and you have to have at least one judicial day.
Yes, Your Honor, and I'm asking for, I guess, a day.
Well, it's not happening, okay? So I'm not going to consider it right now. All right?
Can I give the court my case that I found about this jurisdictional issue in terms of divesting?
The Manley case?
Well, mine's called Morgan Stanley.
Got a site?
Well, it's a district of, it's a federal district opinion, 2015, U.S. District Lexus 155454,
And what's the
But-
case name?
Morgan Stanley versus Couch. And I mean, I recognize it's just a district, it's just a district court case, but it cites all of the federal case law on this issue, including the U.S. Supreme Court decision. And again, I understand it's not just absolute, just because we filed a notice of appeal, that in every case, district court would always be divested of jurisdiction. It is more complicated than that. And this case kind of outlines what the rules are, as far as I can tell. But I only had a couple of minutes to do the research, so.
Okay.
If you'll indulge me, Your Honor, because it's complicated. Thinking about this, if the position is that we can't be heard on the newest ex parte motion, then that should be part of the record that goes up on appeal, so I just want to.
I have to agree. It was actually filed 2 minutes before the notice. of-
Like I said, I'm sure that I wouldn't have a problem with that, and even if I did, then, we would file an appendix and then they would file their appendix. So it's not an issue.
Okay,
Okay, and then I just wanted, because we have the problem of the two things hanging out there, not being protected, that are very important to the review journal's rights and the other movements. I just want to say for the record that I hope that Metro will not take any steps to search any of that material because it's fairly encompassed within all the issues that we're talking about here.
well, and frankly, I want to review these cases. This is new to me. I mean, I've never had a preliminary injunction place dealing with some stuff, a notice of appeal, and then a second motion for preliminary injunction. In the same matter is the deal.
The only reason that the car issue came up, it's in the papers, is that an expert in the area of electronics spoke to both of us and told us about the concern. And as soon as they did that, we took steps to protect the car. So it's not like we just keep doing it. It was a thought that nobody had because, like your husband, some of us don't necessarily have electronics in their car, so that they would think about like this. So we just want the court to understand it wasn't done to complicate. It was done because it's something that came to us and we had an obligation to define it, to try to protect it.
And it came after your hearing last week, Your Honor. So
Okay.
a call from a concerned citizen.
I understand, but now without even reading your motion, I don't even know what kind of car Mr. Gehrman drove. Who knows? Maybe he drove my family actually owns a Model A.
We have evidence in the record that it was a less than 2-year-old Honda Civic. So it's definitely a Bluetooth, very modern car. And we even put in the record the manual for such a car, which tells you everything that gets uploaded into it. So that's all before you. It's all in the record. I guess you're going to have to decide whether that still remains before you or as part of the record on appeal. But
Okay, well, I'd sure like to see any research anybody has that once there's an appeal done and you've got another motion for preliminary injunction or TRO, do I have jurisdiction to hear that? I'm not sure. But,
we'll take a look, Your Honor.
okay?
Your Honor, are you able to hear me? This is Adam Osborne.
Sure.
So I certainly can speak to that, but I won't give a limited or non-existent role in this case. I wanted to briefly
What?
refer
And I'm sorry, your name, sir?
Adam Osborne, I'm with Donald Brown on behalf of the Reporters Committee.
Yes.
Request for Amici. I just wanted to briefly be heard on that issue because we will be seeking to participate on appeal, but to the extent there are issues that this court continues to address separate from that appeal, we would ask you to grant our motion for leave to participate, and only because we will not be requesting to be added to the caption, we won't be participating in the motion practice. Our only request is to submit one brief, which this court can review or not.
Okay.
And so we hope not to add to any procedural complexity, but because, and I won't speak to the procedural issue, although I do have some experience with that, but our request is to the extent there are certain future proceedings that are outside of the matters that are on appeal, simply to have a brief on the record.
Okay, I had already denied your motion. Most certainly you can work with the Las Vegas Review-Journal. You can certainly do your request to the Supreme Court, but at this point, I just don't think it's appropriate at the lower court level. All right? But certainly I appreciate you being here and so forth. But anyway, I think we're done.
Thank you, Judge.
All right.
Thank you, Your Honor.
Thank you.
You've been watching Breaking News from the Las Vegas Review-Journal, sponsored by Michael Gaughan's South Point Hotel, Casino, and Spa.